Is that correct?
Yes, I am.
All right. I do see Mr. Losiewski is with us as well. Ms. Spillane, can you update me as to this case?
This matter was adjourned from January 23rd to allow the plaintiff to pay $392 by February 6th, and then another $392 payment by February 20th. And that if this had been done in advance, we could advance it to the next month. And if there were no payments, then she could potentially face jail time. We have received $619 for February of 26. Ms. Bagby has also reached out to let us know that there were some situations that limited her ability to make the full payment.
All right, Ms. Bagby, what happened?
Your Honor, I hit a couple speed bumps in achieving my goal this month. The weather caused a slow month for us at work, between us getting stuck in driveways and not being able to get to the houses, and then the bad roads delaying our start time 2 to 3 hours or making us end early a few hours a couple times. We just didn't get the hours that we thought we would. I was also sick one day. My boss missed a day when her son joined the Marines. Plus, a few clients canceled the day of cleans for personal reasons. Like one client canceled because she had to clean her closet. My boss, I'm scheduled 8:30 to 5 every single day, but my boss told me, she's like, I could write a letter if they want. This is a very slow month because of the weather, and she's worried about me being in trouble this month because it was slow. But I work with her 5 days a week. I'm one of the most reliable employees that she has. And I've been making consistent payments on Monday. My plan is to continue to consistently make payments on Monday. I get paid on Mondays now. I make the payment as soon as I get paid. We stop at Walmart, so I can do that. So unfortunately, I did hit some speed bumps this month in achieving my goals to make the full 2 payments. I also realized I calculated the payments wrong. For some odd reason, I thought the amount was $377 or $388. I just heard $392 on the record. So I'm correcting that. But I can make another payment this Monday, and I'll make another payment next Monday. And I also am sorry about not being able to get to internet today. I received a message at 2 in the morning that my phone was out of data. And I live in Akiak Falls, Millersburg now. I moved and I left my boyfriend and by myself. And I was freaking out because I don't have a vehicle yet. I'm buying a Jeep next week. So I wasn't able to get to the library or get to Wi-Fi, but this will not be a problem from now on. Next month, I will be able to log in on Zoom like I'm supposed to.
All right, thank you. Mr. Losiewski, is there anything that you want to say today?
Other than the weather's been a factor for me as well, and I completely understand the road conditions and the way the cold is, and I don't have any problems at all with whatever you decide today, because I get it completely. It's terrible. All
right. Well, thank you for that understanding. Ms. Bagby, it does appear to me that you've made a substantial payment towards your requirements, which is a good step in the right direction. So I appreciate that. It does appear to me that you have a reasonable plan for continuing to make your payments on Mondays, and that you are working. So I am going to allow you to slide a little bit this month because it does appear to me that you've made a substantial effort to do what I asked you to do. I'm going to expect that you're going to make that up in the future. So let's be working towards that. But as long as you're making substantial payments, doing what you're supposed to be doing, working as hard as you possibly can, I can certainly understand the weather a little bit. And so keep doing what you're doing. We're going to adjourn this out for 2 months. I'll see you in April. The friend of the court will send out a letter or a notice for the next court date. Hopefully we'll be able to see each other face to face over Zoom at that point, and they'll be able to tell me that you've made all of the payments that you're required to make, and things will be going well. So any questions that you have, Ms. Bagby?
No, Your Honor.
All right. Thank you very much. I'll see you in April.
Your Honor.
Yes.
Just to be clear, so she's paying the right amount. Her monthly obligation is $388, but we recently had done a calculation to do the ordered on arrears, and that came out to $183.96. So she should shoot for $571.96 a month.
Can you say that again, please?
I can. The monthly obligation is $388, and then the ordered on arrears amount is $183.96.
Okay.
So the total that we're hoping for is 571.96.
572. We're just gonna round right up. Okay. All right. Thank you so much for that.
Yeah, no
All
problem.
right. Thank you for that clarification, Ms. Spillane. That's all for today. Thank you, Ms. Bagby. Thank you, Mr.
Thank
Wosiewski.
you.
Thank you, sir.
We have Ms. Burns with us.
Hi, good morning.
Good morning. We're here monitoring. Ms. Spillane, can you update me as to how things have gone?
Certainly. So this matter was adjourned from January 23rd. The plaintiff was to continue to make full monthly payments before today's hearing, and that if no payments were received, that she could potentially be sent to jail. Her monthly obligation is $256 with an additional $128 ordered on arrears, bringing her monthly obligation to $384. Balance is $8,117.20. There was a payment made on February 25th in the amount of $384. However, that has not been factored into the balance yet. Ms. Lounsbury Burns did inform me that she was employed, but now she is no longer employed.
What is her monthly obligation again?
The total with the ordered on arrears is $384.
So she did make a full payment this month.
Correct.
All right. Ms. Lounsbury Burns, what's your status of working?
I'm still looking right now, but as of right now, my payments will be made in full by my husband. I will not miss any payments.
That's a good idea. All right.
Thank you.
We will adjourn this matter to make sure that you're continuing to make those payments. So I'll see you again next month. Is there anything else that we need to do today, Ms. Spillane?
I don't believe we have any court dates available for March, so we'd probably have to do April.
That's fine. I'll let you pick the date to set that. Ms. Burns, you'll get the notice in the mail. I'll see you when that happens. All right. Thank you very much. That's
Thank
all.
you.
Yeah.
Ms. Spillane, can you update me as to the status of this matter?
Yes, sir. This matter was also adjourned from January 23rd. The defendant was ordered to pay December, January, and February prior to today's hearing, and that the show cause would be adjourned month to month for 6 months to make sure that her payments were to continue. And if she did not pay, that she would potentially face jail time. I did speak with Miss Ryder earlier this week regarding some medical issues that she was experiencing, and she had been hospitalized. She did make a $120 payment in January, and then it looks like maybe there's another payment made on her other case. I'm not sure if maybe it dispersed that way or if that was an intentional. But prior to that, the last payment we had received was in May for $5. Her monthly obligation is $51.
So she's $30 short of paying December, January, and February.
Correct, but she was also hospitalized during that time too. So I also believe she may have lost her employment at that time.
All right, Ms. Ryder, what do you have to say?
I went, so what happened? I lost my job because I got picked up on a child support warrant, when, for my son. And the only thing that they picked me up is it didn't get, income withholding, didn't get to you guys and to my job. So when I was taking my son to laser tag, I got pulled over and put in jail over the warrant. I said a weekend in jail. I got let out. Because and I was told that I had to make a payment on his case. After that, I ended up in a mental hospital for a week. I just got out 2 days ago. I have done extensive job search. I was trying to send it to Tara and to Shasta, but it would not send over. So I'm gonna have to go up there and either show them or print it out. But I have applied to 48 jobs prior to me getting it into the mental hospital. I've been trying to get a job. I've been, my mom's door dashing, so I was gonna ask her maybe if I can make a payment with the money that she helped gives me for doing that. I'm trying to get a job. I fractured my wrist while I was in, or my arm while I was in the mental hospital. But I am trying to get everything in order and do what I need to do so I can start paying for everything.
All right. It sounds to me like you've made a substantial effort, and I want to say thank you for doing that. The fact that you made most of the payment shows me your good faith. The fact that you've made some 48 job applications, that's a good faith effort as well. And it appears that you've got a good reason and have made the efforts on appropriately. So I'm going to simply monitor what you're doing. My general rule is you got to make at least 10 applications a week, and then those need to be sent into the friend of the court's office. Sometimes it's easier if you just spread them out on a desk, or put them in a list and then take a picture of it and send the picture, as opposed to all the documents themselves, as long as they can read it and confirm that you've made 10 different applications. That's the biggest thing.
Okay.
And then if they have any questions, make sure that they have a way to call you so that they can discuss that with you if there's any questions about what the applications show or where you went, or they can't read something or like that. So we're simply going to adjourn this out for another month. We'll see what you do in another month. Continue to make your payments, or at least a good faith effort towards those payments. I'm glad that you're now out and feeling a little bit better, and I'll see you in a month. Actually, probably be 2 months. We'll bounce it to April because my March dates are pretty constricted at this point. So anything else we need to do today, Ms. Spillane?
No, sir.
All right. So I'll see you in about 2 months, Ms. Ryder. Thank you.
In this part, a mother recounts being arrested on a support warrant, losing her job, and spending time in a mental health facility. Despite the chaos, she shows proof of 48 job applications and partial payments. The judge looks beyond the setbacks and focuses on effort. Instead of punishment, he orders continued monitoring and consistent job searches. It's accountability balanced with recognition of genuine hardship.
You.
This is a show cause. Ms. Spillane, can you update me as to this matter?
Yes, I can. This matter was adjourned from January 9th to monitor the defendant's payments and allow her the opportunity to file any kind of stipulations or motions. She has filed a few motions as of today that are set to be heard on April 8th. She has a monthly obligation of $136 and a current balance of $6,025.34. We did receive the bond money in February, and then she also paid an additional $140. Her monthly obligation is $136 again, so she has met that obligation for this month.
All right. That sounds good. Ms. Mertz, when is your case going to be heard at the friend of the court on your parenting time motion?
April 8th.
All right. That may have an impact in the future on your child support, but it doesn't change anything right now. So your obligation continues to be that $140 a month. And so I expect that to continue to be paid until you have a change, if any, in based on that parenting time motion. Do you have any questions about that?
No, Your Honor.
All right. Mr. Mertz, is there any information that you want me to have today?
No, Your Honor.
All right. I'll see you next. We're going to set another review hearing or status conference hearing in April. My March calendar is full at the moment, so I'll see you in 2 months. That should give you an opportunity to go to the friend of the court, find out what happens there and see where we're at. I would expect that you're going to make your payments on time for the next couple of months, though. Any questions, Ms. Mertz?
No, Your Honor.
All right. That's all for today then. Thank you very much. Good luck on your motions.
Thank you.
This was set for a show cause hearing. Ms. Kraus, can you update me as to this matter?
Yes, this hearing has been adjourned 4 times from the referee to address contempt, as the defendant has failed to pay anything since the uniform support order entered. He's not made a diligent effort to pay anything at all of the amount that's due. and the defendant does not have a physical disability that prevents him from working. The defendant's support obligation is $703. The overdue support balance is $16,103.50.
When did the Uniform Child Support Order enter?
It entered on August 8th of 24 with an effective date of March of 2024.
That's not fair. Hold
on, I'm trying to mute this.
Thank you. All right. And the friend of the court indicates that there's been no payments at all since at least August of 24.
Correct.
Mr. Bennett, what do you have to say for yourself?
I'm in rehab right now, as time being. My plan is to get out and go to work after this, after I get out of rehab, but I'm in rehab right now. I did start a new program that's gonna hire me a lawyer or pay some of my child support. So I am addressing it. But I am in rehab right now, not working.
When did you enter rehab?
About 3 months ago, October 28th, maybe 4 months ago.
Where are you physically located?
Flint, Michigan.
What's the nature of your rehab there?
What do you mean nature of it?
Well, is it an inpatient program? Are you free to leave?
Inpatient. No.
Since October? Since October?
Yep.
You're not able to leave campus?
No.
What's the name of the facility that you're at?
Odyssey House.
Who's the gentleman that's with you there today?
My counselor.
Your Honor, I'm Tim's counselor. He's currently at Flint Odyssey House, has been since October. We're a long-term inpatient residential treatment center for drug addiction. We did just sign him up for a program that we have called Impact, which is going to help either pay some of his child support or get him like legal representation on the matter. As of right now, there's no anticipated discharge date because our program can take over a year sometimes. And he's unable to leave the campus at this moment and get a job and work, but he did express to me that he plans on addressing this matter moving forward.
All right. Ms. Schultz, do you have any additional information that you'd like me to be aware of today?
We have been we've tried to help him and give him the chance. And when we were in front of Mr. Legal last month, I made it known that he is able to pay on his fines in Jackson since October quite a bit. And regardless if he doesn't have a job or not, someone's paying those fees. Since our last court date, I did look it up last night, he has had a suspension on that, so he doesn't have to pay on that or address that until March. So it's been pushed out until March. He's supposed to pay on it, but I'm sure that he went to them or something's happened because he doesn't have to pay right now. But since he has been in rehab, he has paid quite a bit to those fines, and I have seen nothing. And I understand that he can't work, and I understand that addiction is a process, but it's also frustrating on my end. That's it.
I can certainly understand your frustration. Mr. Bennett, as to the payment of fines and costs, but not child support, what happened there?
Like I said, I'm going to rehab. I'm not working now. I'm not working at all.
You already told me that, but she says that you managed to pay some money towards fines and costs, but you haven't paid him a dime towards child support.
No, I didn't.
That was what my question was.
I didn't. She's not correct. I didn't pay fines and costs. I don't know where they got paid at, but I didn't pay it.
I can share my screen, and of course I can't see who paid them, but I could share my screen with you and look it up on his case in Jackson County.
All right, so Mr. Bennett, so who's paying money on your behalf to Jackson County on your fines and costs?
I have no idea. I have no idea, sir. I didn't even know if someone was paying.
I find that really hard to believe.
Yeah.
Money doesn't just magically appear in a court's bank account.
That's the truth.
And I also kept pushing it out and letting Mr. Legal push it out and give him the benefit of the doubt, you know, and Mr. Legal knew about this and said, well, you know, if you can make a payment, then we don't have to put out a warrant. And since then, he's reached out to 2 other family members trying to get them to take Adam without me knowing to see Tim. It's very frustrating. I'm in a very, it's tolling. That's it. Frustrating.
All right. If Mr. Bennett, and it does appear that Mr. Bennett is in a rehab facility, inpatient, and I have no reason to believe that he's not, the court is not able to take sanctions against him for failing to pay his child support. Once he leaves that facility, that is no longer true. So Mr. Bennett, if other bills that you have are being paid, whether that's through the gifts of somebody else or not, and you are not making any payments towards child support, you will be subject to the court's contempt power upon your release from the facility that you're in. That means as soon as you're out, you're mine. You understand what I'm saying to you?
Yes, yes.
Don't play games with me. If you've got money available to make your child support payments, make your child support payments. Even if it's not a full payment, any payment would be something rather than nothing. And if you've paid nothing since 2024, you are highly likely to go directly from your rehab to jail. Do you understand what I'm saying to you?
Yes, I do. Yeah.
If there's any way that there's a program in the rehab facility that you can gain some assistance through child support and you can begin to make some payments, I would say that that is highly in your best interest to do so. Do not take the court giving you grace now for the court being unwilling to put you in jail. I have no such problem. You understand?
Yeah, I'm aware of that. I'm aware of that.
Good.
Buckle up, guys. Today we're diving straight into one of the tensest courtroom moments you'll see. A father sitting in rehab thinks that shields him from consequences, but the judge isn't buying it. With over $16,000 owed and accusations that other fines are somehow getting paid, the pressure builds fast. Then comes the warning. Once he's out, jail is on the table. It's a stark reminder that recovery doesn't erase responsibility.
So we're going to adjourn for 30 days. We'll find out whether or not you continue to be in rehab, and we'll keep monitoring your position at the facility in Flint. As soon as you're out, I need to see payments in full starting. Clear?
Thank you. Thank you.
All right. We'll adjourn for 30 days. Thank you very much for being here, Ms. Schultz, and giving me that information. I'll see you in 30 days, Mr. Bennett. Make sure that you're making some progress. That's all for today.
Thank you, Judge.
I do see Mr. Carey.
Yes.
Mr. Carey, there is a show cause. The hearing was to monitor your monthly payment obligations after you're released from jail. Ms. Kraus is here from the front of the court. Ms. Kraus, can you update me as to any payments that he's made or what the status of the case is?
Yes, since his release, we have not had contact with the defendant specifically, but someone has made payments totaling $620 on behalf of him, $200 on the 24th of this month, and $420 yesterday. These payments are still pending disbursement. His obligation is $946. The sum is composed of $636 for current support and $310 towards overdue support. His arrears balance is $31,838.53.
Mr. Carey, what have you done since your release?
I've been trying to get a job, and I also paid $320 this morning on it.
So you believe that you're up to date as of the
Yes.
monthly application?
Yes.
All right. Mr. Kraus, is there a way to confirm today's payment?
Yes, if you don't mind, give me just a moment.
Yep, please. While she's doing that, Mr. Carey, what have you said you've been looking for work. What have you been doing for that?
I'll put in job applications and whatnot.
How many?
Filling out apps.
How many job applications have you put in?
6. And I
How
should
long
be
have you
hearing
been
back
out?
from since January 15th.
And you put in 6 since that time?
At least, yeah.
What are you doing with the rest of your day?
Working to get money to pay off that $900.
All right. What kind of work you been doing?
Construction for some people that I know around their house and stuff, and cutting down some trees.
All right. Typically, I ask people to do, if they're not working full time, I ask them to do 10 applications per week with that information sent on a weekly basis to the friend of the court's office until you're able to obtain full-time employment. Is there any reason why you can't do that?
No.
All right, we'll make that part of the order then. Ms. Kraus, have you been able to confirm the payment for today?
Yes, I was able to confirm that he made that payment.
All right, looks like he is up to date then on his payment for this month. Thank you for that, Mr. Carey. I appreciate the hard work to get that done. Let's keep doing that. We're going to adjourn this out for another 30 days to monitor. Typically, until you get a full-time job and we can do an income withholding order, we'll keep doing this to make sure that you're on track because you do owe a huge number for arrears. So we're going to make sure that we keep you on your toes for that. So we'll have a hearing set next month. Friend of the court will send out the notices for that, and we'll do the same thing that we did today. Any questions that you have, Mr. Carey?
No, Your Honor.
Ms. Kraus, is there anything else that we need to do today?
No, thank you.
All right, that's all for today, Mr. Carey. Thank you very much.
Thank you. Bye.
This is the matter of Amanda Sue Lane and Timothy Brewer. Ms. Kraus, can you update me as to the status of this matter?
Yes, there are 3 cases in regards to Mr. Brewer this morning. In regards to Amanda, this hearing has been adjourned 4 times, most recently from January 23rd. The defendant appeared late and the bench warrant that was issued was recalled. He was required to pay $700 to friend of the court by January 23rd, which he did. Of that payment, $238 dispensed to this specific case. The arrearage balance on this case is $2,204.19. And then commencing February 1st, the defendant was expected to make full monthly payments of $408. Mr. Brewer did present this morning at the front of the court counter and made a $700 payment. We are unsure as to how that amount will disperse to this specific case today.
But it appears that he's made at least a good faith effort to make substantial payments as required in this case. Is that correct?
Yes.
All right. I'll let that. I'm sorry. Go ahead, Mr. Brewer.
Well, Your Honor, I just wanted to state that last time I had stated about, I believe the payments were $333 a week I needed to make. Obviously, that did not happen. I do want it to be known that I got on the expert pay and I set that up so I can try very hard this month to make those weekly payments. So it's not at the end of the month in 1 lump sum.
I appreciate that, sir. That shows that you're thinking ahead and planning ahead, and I appreciate that for doing that. So for this case with Ms. Lane, that appears to be appropriate. I'm going to call your other 2 cases next, and then we'll see how things went with that. I anticipate hopefully that those will go the same way.
Okay, I appreciate it.
All right. Heather Taylor or Heather Ford and Timothy Brewer. That's file 16-16267-DS. Ms. Kraus, how's he doing on that matter?
For this specific case, he has an arrears balance of $20,486.24. His monthly support obligation is $546. It's composed of $376 for current support and $188 for overdue. And again, he did make that $700 payment that will disperse between the three cases.
All right, so has he met his monthly obligations for this case as well?
No, that $700 will not meet the obligation for the three, just the good faith effort of making payments.
All right.
Well, there was two $700 payments, Your Honor.
This morning you paid $1,400?
No, I paid $700 this morning and then $700 after our last. So since our last court date, Your Honor, I've paid $1,400.
$1,400, correct, that will disperse between the three cases.
Right, and she's simply saying that that second 700 split between the three cases does not satisfy all three cases fully, although it is a substantial payment as to all three cases fully. So you still got a little ways to go, and you've told me that you're now having that come out weekly so that you're able to make that a little bit easier. So we'll go ahead and say that you've met your obligation for today's purposes anyway in that file, second file as well. And then I'll finally call the third file and we'll make that finding as well. All right, this is Kaylee Jaraneski and Timothy Brewer, file 24-19758-DS, set for an order to show cause. Ms. Kraus?
Here, the focus shifts to a father juggling 3 separate child support cases. After previous bench warrants and missed payments, he walks in having dropped $1,400 in an effort to show good faith. It sounds impressive until it's divided across multiple cases and still doesn't fully satisfy the monthly obligations. The judge acknowledges the effort but makes it clear partial progress isn't full compliance. The clock is still ticking.
The defendant's obligation for this specific case is $342. There's no ordered on arrears. There is arrears balance of $3,466.52, and it's indicated in the prior ones that that payment has been made that will disperse between the three cases.
All right. I do find that there's been substantial compliance with the requirements. Mr. Brewer is going to continue to try to make his obligations in full on all three files. So we'll adjourn all three matters out another month and see how he does as to that. Any questions, any comments that you have, Mr. Brewer?
No, Your Honor.
Ms. Kraus, anything else that we need to do?
No, thank you.
All right, that's all for today. Thank you very much, Mr. Brewer. Have a good day.
You have a good day. Have a good weekend too, Your Honor.
Thank you. Ms. Kraus, can you update me as to this matter, please?
Yes, this hearing was adjourned from January 9th to monitor the plaintiff's good faith efforts to pay and for friend of the court to submit a new support recommendation. Since the hearing, the new uniform support order entered on February 3rd that changed the support obligation from $1,012 to $764. The plaintiff has paid $1,000 on February 9th. The arrears balance is $21,020.15.
All right, so he's met his obligation for this month. Mr. Hoyt, do you have any questions for the court?
Not at this time, Your Honor.
All right. I would imagine that you're somewhat pleased with the new support order as it's substantially less than the old support order.
I am. It definitely helps. Gives me a better ability to budget.
All right. What I'm going to do is I'm going to continue to have this for a show cause, at least a monitoring process for the next month or two to see that you're continuing to make your payments on time. And once you do that, I'll give the friend of the court discretion to take it off that. So I'll see you again next month and then maybe the month after just to make sure that you're doing things. And if things are continuing to go well, we'll just put you on the normal payment plan and I won't need to see you on a regular basis. All right, sir?
I'd love that.
All right. Have a good day.
You too. Have a good weekend, sir. Thank you.
This matter was adjourned from January 9th to monitor Mr. P's payments, and that if he was unable to make a full payment, that he must supply 10 job searches. His monthly obligation is $154 with a balance of $3,663.65. For February, we have received $119.92. I did speak with Mr. Pease recently, and he anticipates work will pick up next month.
So he's made about a 3/4 or 80% payment for this month. All right, Mr. Peace, how come you weren't able to make your full payment?
So, due to my unemployment right now, I'm only, able to get the minimum benefit amount, which is the 322 biweekly. I did mention the other day when I talked to my caseworker that I also have my daughter, who I pay child support for, which is a substantial amount. I was supposed to have a hearing on February 12th to do a review for child support, which got adjourned to March 26th. So I'm hoping to get that lowered a little bit, kind of help me out. But it's just due to my unemployment and the amount that I'm getting, it's just the amount being withheld isn't enough to, complete the full payment. I did take steps as far as getting a hold of my employer to get confirmation of going back to work, which we will this spring, which will increase my pay to be able to make full partial, or not partial payments, but full payments. I also took steps for future reference to applying at Alpena Community College. So I will be doing courses to help move along the process of getting a contractor's license to prevent this from happening again. But I'm doing the best I can with no excuses. With the partial payments, I'm just stuck in a situation right now, and I'm doing the best I can to get out of it, so I can prevent this from happening again.
Well, I appreciate the partial payments, and I do appreciate the work that you're doing with the education to better yourself so that you're not stuck in this revolving door of working and then not working and getting behind in your child support payments. Did you contemplate part-time work while you're on unemployment?
I did contemplate it. I just, with some assistance that we are getting through the state, with me and my wife made some discussion, or had some discussion about it. It's been a process getting certain things that we have now, and I didn't want to alter any of it. I'm not trying to make excuses. It's been a revolving door of, no luck in my favor, and I just didn't want to alter it, especially getting confirmation that I will be going back to work next month.
All right. I'm not going to denigrate your decision-making process. Just take this as a word of advice as opposed to a court order. All right. It's always been my experience that being on assistance tends to keep you on assistance. And if there's anything that you can do to stay off of assistance, that's always the best thing to do. I think you can see it kind of limits what you can do and where you can go and how you can do things. And it tends to end up make you, like with your child support, it leaves you at the mercy of a judge on the other end saying you're not doing enough.
This final segment centers on an unemployed father making partial payments while receiving state assistance. He explains his limited benefits and plans to return to work soon. The judge accepts the effort, but delivers a pointed lecture about relying on assistance and the importance of standing on one's own feet. Monitoring continues, expectations remain firm, and responsibility stays front and center. If you found this breakdown insightful,
So I'm not going to second guess your decision making here because it appears that you're going to be working relatively soon, and I'm going to require you to make up for the losses, if you will. And I can see that you're making an effort. You're not just letting it go. So I'm going to give you the benefit of the doubt. But for future reference, staying off of assistance or limiting the amount of assistance and doing your own work and standing on your own 2 feet is always the best policy. And I'll just leave it at that. Okay.
I agree 100%. Coming from me, you know, it's definitely not something I'm very proud of. It's a very humbling thing, and definitely a hard pill to swallow. But
well, I think we're going to be okay then. So what I'm going to do is I'm going to simply monitor this again next month. Hopefully that means that you're working and you can start making your payments. And I expect that you'll make up for these months that you were a little light on that. So let's plan on doing that. And I'll see you again. Actually, I think my schedule's a little tight in March, so I probably won't see you until April. So we'll bounce it to April. We'll monitor how things are going. Hopefully by then things will be going well for you and we won't have to have this conversation again. All right, sir.
Sounds
That's all
good to
for
me,
today.
sir. All right. Thanks, sir.
All right, Mr. Wiggs, you're here today for a bench warrant arraignment. Let me ask this friend of the court first. Ms. Spillane, is this the warrant that was issued in August of 25?
I believe so. Let me just double check that date for you real quick. That is correct, Your Honor.
All right, thank you very much. Mr. Wiggs, there was a failure to appear at a August 22nd, 2025 show cause hearing for this court, after which a bench warrant was issued for your failure to appear. A cash performance bond in the amount of $2,500 was set. Can you tell me what your status was in August 22nd of 2025? Where were you and why did you fail to appear?
I failed to appear, Your Honor. As I seen the last time, Your Honor Hesselink, I was here in the jail. They released me in July. I went to Florida. I was working with a guy named Cody Mork out of Boyne City, Mark Payne. We ended up going to Florida, Lehigh, Florida, Southwest Florida. I was there working. He was supposed to be I gave him the information for my son's account, which is my court case as far as the 98077831 DM. He was supposed to be paying our child support. 2 of us were paying child support through his crew. Failed to do so. I come back to Michigan because it was sour. I come back to Michigan and got picked up on an old charge of obstruction of justice through Everett County. I'm doing a year now. They just give me a year. I've been here since fall.
What is your earliest out date?
August 18th this summer, Your Honor. And I'd like to just briefly say, Your Honor, no excuses at all, Your Honor. I'm 59 years old here in a few months. Last few years have been kind of rough for me as far as no excuses, not at all. I've been battling alcoholism for a long time. All right, that's no excuse.
All right, thank you, sir.
You're welcome.
When were you in? I'm sorry.
Go ahead, Your Honor. My objective here is sober living. I've been working with Bear River Health. Her name is Mercedes. I don't know the last name for her, but there's another one. Her name is Kathy McGuff. She's got me into sober living. There's Gaylord, Lansing, and Sheboygan. I prefer Gaylord. I've had always great success with Gaylord in 21, 22. Things are being met. Miss Tara Spilling, she was great, and she let me do a step down order from the outrageous I was paying to $200 a month. Well, that's very feasible. Absolutely it is. And my wages are high. You know, they took my driver's license. She, I believe, took my old caseworker's position, which was Luann Dean. She had took the driver's license. That kind of hindered me. Then I went through a depression, you know, paying outrageous child support and lost a father. And, yeah, like I said, there's no excuses, but it was a downward spiral, man. It's time for me to fly right because I'm 59 years old, man. You know, how much more quality of life do I have? You know, I definitely want to start making these payments and it's arrears, sure, but still, you know, it's crazy. So that's my goal, Your Honor, too. My plan.
Thank you, sir.
Is sober living, sir.
All right, Mr. Wiggs, can you tell me when you were incarcerated on the current charge that you have right now?
October 18th. I did some fine before that and was released, and then I was picked up on this charge in October.
All right. So the statute in Michigan says that if you are incarcerated for more than 180 days, your child support matter can be placed into abatement status. And it appears to me that you would qualify for that if your earliest out date is August of 25. So that would be almost 10 months that you would be in jail. So what I'm going to do is, and it also appears to me that you were only out for a short period of time in Florida and before you were re-incarcerated. So I'm going to withdraw the bench warrant because you're incarcerated now. So there's really no purpose served in having a bench warrant outstanding. And I'm going to schedule this case for October to see when you're going to be released and what your plans are, in August. So we'll see what your plans are, where you plan to go, and whether or not you're going to get into that sober living house and what those things will do. So we'll schedule this for a status conference in August, probably be sometime close to when you're going to be released, so we'll know more about you. I'm going to direct the friend of the court to abate, that is to take off temporarily your child support responsibility so that it doesn't keep getting larger while you're incarcerated because you're not able to work and make your payments while you're incarcerated. And then once we know a little bit more about you in August, about when you're going to be released and where you're going to go and what your ability to work is, we can decide whether or not to reinstate your child support at that time. Do you have any questions about that, sir?
Yes, I do, Your Honor. Not to correct you today. I read a book just about you. You're a famous guy. Anyway, it's arrears, Your Honor. And I'd like to say that if they debate this warrant, I understand that it won't grow any further because my children, one's an oncology nurse there on Center Street, and the other one works for MedLife and one's United States Marine. So them children are.
This segment features an incarcerated father facing a bench warrant for failing to appear. He explains job troubles, a move to Florida, and ultimately landing back in jail. Despite the crushing arrears, the judge applies the law carefully, recognizing that long-term incarceration qualifies him for temporary abatement. The warrant is withdrawn, and support is paused while he's locked up. It's a rare moment where procedure, not emotion, dictates relief.
Late 20s, early 30s. So that's arrears there, sir, and I understand that's money right there. But as you said, you were going to drop the warrant and schedule me for a hearing sometime in August of this year, 26. Yep. Okay, so can that paperwork be faxed here, sir, so I can have copies of that?
Ms. Spillane, will that be able to accomplish that?
I think we can probably do that. We may need to have him at least temporarily update his address to Emmett County Jail, but we would be able to mail that to him at that point. We can fax the change of address information to the jail.
Okay, and that warrant will be dismissed for now.
Yes.
Okay.
Ms. Spillane, rather than wait for him to have to send the information back and forth, we can see that he's at the Emmett County Jail. Can I just order that his address be changed to there?
Yes, sir.
All right, let's do that. That'll make things a little bit easier. There's no doubt in my mind that that's where he's at. So we'll send that information to them. That may come in the mail, sir, so it might take a little bit of time, but we will get you that documentation that you're requesting from the friend of the court's office. So we'll withdraw the bench warrant. We'll set this matter for a review hearing in August of 26, and we'll see you at that time. Any other questions that you have, sir?
No, thank you, ladies. Thank you, Your Honor. I'd like to say that, hey, the book I just read, great stuff, man. Great stuff. And I'll just say that yes, you know the book. Have a great day, sir.
Take care. Bye now.
You too.
This matter was adjourned from January 9th to monitor the defendant's payments. You had told him that he needed to pay his full obligation, and if it was not paid in full, that he could be found in contempt and potentially jailed for 7 days. We did recently receive a $250 payment that is still processing and has not been credited to his balance yet. His monthly obligation is $348, and the balance is currently sitting at $13,951.43.
So he's paid about 2/3.
Here, a father learns that his $13,000 balance stems from an out-of-state order enforcing arrears only. He claims confusion about the recurring monthly amount, having paid just $250 instead of the required $348. The judge clarifies the obligation in direct terms. This isn't temporary, and it won't disappear quickly. The message is simple. Misunderstanding the order doesn't excuse falling short.
Correct.
Mr. Wolf, what's the deal with only paying 2/3?
I didn't know there was a monthly, reoccurring monthly payment. I paid $250 in January when we had court. The check after that I used for bills. The check or the payment I just made the other day was to go towards this. I have another payment next Friday when I get paid. Hopefully I can get everything squared away.
All right, Ms. Spillane, is this all arrears, or is this a monthly obligation
Correct.
plus some amount on arrears?
This is a order out of South Carolina that we're enforcing. It's arrears only, but the ordered on arrears amount is $348.
All right, do you understand that, Mr. Wolf?
I do now, yes, sir.
All right, so I expect in the future, $348 or close to $350 every month.
Yes, sir.
That's going to be your obligation, and that's going to be quite some time that you're going to be paying that because you're 13,000 plus behind.
I understand, Your Honor. It
All
will
right.
be paid.
All right. So it appears that you've made a substantial effort. You got 250 out of the 348. It's not perfect, but it's something. So I'm going to give you the benefit of the doubt. I think you've heard me say to the other people that I've got no time left in March, so I'll see you in April to monitor how you're doing on that. Again, you need to start making that up. If you're paying behind on 1 month, you need to pay more in the next few months after that to make up for it. But make your payments, get them on time. Eventually, if you start making them on time on a regular basis, then I'll just say you can do it on your own and you don't need to come to these meetings. But until I get you on that regular basis doing it in the full amount, you're going to still keep seeing me. Any questions that you have, sir?
No, sir.
All right, that's all for today then. I'll see you in 2 months.
Thank you, Your Honor. Have a good day.
You too.
Elliot Blumberg on behalf of Kerry Williams, who's appearing via Zoom from my office.
All right, Mr. Straw.
Morning, Judge. Joel Straw on behalf of Jacob Williams, who's joining us on Zoom.
All right, this is a hearing on an objection to the ex parte order involving possession of the marital home, and then most likely we'll do a pretrial after that. So, Mr. Straw, is this your objection?
It is, and I'll say this, Judge, while we adamantly deny many of the allegations in the ex parte motion that was filed, the fact of the matter is that Mr. Williams has kind of landed on his feet, found somewhere else to reside. He has requested a number of items of personal property from the marital residence. I've communicated that to Mr. Blumberg by email on February 10th. It's my understanding that his client is willing to allow Mr. Williams to take possession of those items. Doesn't necessarily mean that as the divorce rolls out that those will be his, or that there's no claim by the wife. However, the possession for the time being is what we've sought to accomplish. So all that being said, my client no longer has an objection to his wife's use of the marital home, and I think we can move past that.
All right. Would you put that in writing for me, please, just so we have that in the court file, that you've withdrawn your objection to that? That would be helpful to me if you don't mind.
Sure.
And then as to a pretrial. It sounds like the parties are negotiating and communicating appropriately. Either Mr. Schra or Mr. Blumberg, is there anything that the court can do to assist in moving this case forward?
Judge, I think there is certainly some discovery that needs to be conducted. So if you could give us at least the outline of a scheduling conference or a schedule so that we can conduct discovery. I know that we have not yet received Mr. Williams' verified financial information form. So I would certainly ask Mr. Schra to see if we can get that. While there is a temporary agreement as to custody and parenting time, I'm not sure that that resolves the ultimate issue. So we may have to seek the involvement of the referee at some point.
All right, Mr. Schra, your thoughts?
Just looking at the calendar, it looks like we do have a referee hearing in regards to parenting time and custody on the 4th of March, although the parties for a while now have been able to manage those issues on their own. I agree with Mr. Blumberg. It may not be fully resolved for purposes of, ultimately a judgment of divorce, but I'm optimistic. I guess I would perhaps request that the court order mediation at this point in time, and that may inspire the parties to reach an agreement by the time of their final hearing.
Community mediation be sufficient?
I would not request that, Judge. I think the parties can afford and deserve a professional mediator. So I think Mr. Schra and I can come to an agreement as to an individual to perform that task.
Mr. Schra?
I agree.
All right, that's fine. I will order mediation then. Mediator, as the parties agree. As to discovery, 60 days, 90 days, what are you looking for?
I think 90 days would be more appropriate.
Mr. Schra?
No objection.
All right, and then mediation at the end of discovery, is that what you're asking for?
I think we can do it prior to the close, Judge. Again, I think the verified financial information document would be helpful if we could get that really soon.
Yeah, I think if you gave us a deadline at the end of the discovery period, that would work.
All right. And then, Mr. Schra, you have no objection to the verified financial information being exchanged?
No.
All right. Any other issues that we need to put in this pretrial order?
I don't believe so. I think the parties have pretty much segregated their accounts, so bills are being paid as per the agreement of the parties. So there certainly doesn't seem to be any immediate urgency.
All right. Anything else for the benefit of the court today?
No, Judge.
Judge, give me just a second if you would.
Yep.
I'm just reviewing my file, and it doesn't appear that I have the verified financial information form from Ms. Williams. So that is needed too, I suppose.
I'll just say I will ask the parties to exchange required documentation, including the financial information.
That's fine. It's been completed. I thought we had already sent it.
All right. If not, that's fine. We'll just make sure we get that ironed out a little bit. All right. The court will send out a pretrial order with those requirements in it. It looks like you're going to be in front of the referee on March the 4th on your custody, parenting time, and child support issues. We'll have discovery for 90 days, do mediation within that time period, and then hopefully that will get us close to resolving the matters. All right. Thank you, gentlemen. Appreciate your time.
Thank you.
Thank you, Judge.